everything. So you put everything and settle, they will decide and see what is it. I'm using a UK notes, but it's okay. Employment law. Okay, never mind. This is an early one. So who's the employment law, common law statute? This is UK, but doesn't matter. I just take the important one. Who's the employee, same worker? This is UK, so don't worry about this. Implied obligation. These are implied obligation. Take note. These are implied obligation. Imposed to show mutual respect, to faithfully serve the employer. Okay. To faithfully serve the employer, to obey lawful and reasonable orders, to use reasonable care and skill, not to be absent without leave. Not to be absent without to use reasonable care and skill, not to accept bribes and all that. This is implied, so we do not have to write into the offer letter. The implied obligation employer to show mutual respect. This is implied on the employer. This is implied on the parties. Hold on, where is it? Yeah, implied on the parties. Both sides to show mutual respect, save faithfully. This is for employee to save mutual respect, faithfully obey lawful. Okay, mutual obligation employer to show respect for employee. To provide work or pay for employee if there's no work. Pay salary, not to reveal confidential information. To indemnify employee for expenses and costs reasonably occurred, to ensure the employee to take reasonable care. Statutory right, all these are your rights. No problem. Working regulation, yeah, all okay, nothing important here. Yeah, this one is Sex Discrimination Act, UK. So Malaysia we have also. Direct discrimination, indirect, victimization, harassment, discrimination in employment field. Yeah, equal right. This one is for equal right. Okay. This one is not important. Let me see this one. Okay, industrial relation here is introduction, IRA, Industrial Relation Act. IRA provide the regulation for the relationship between employee and the workman and their trade dispute and the prevention. So we have the three party. Look at this. What the employer want, what the employee want. Have a look. Leave benefit, industrial harmony. Focus. Industrial relation. Relationship between law relating to employment, discipline, procedure, and termination. Okay, three-party system. This is a three-party system. See what? Yeah. 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 Virtual IRA. Powers IC are led by the Act. So you go to 1967 Act, everything is there. I think we got the Act just now, right? You go to IRA, Industrial Relation Act. This is Employment Act. You just type industrial. Yeah, relation. Act 1967. Yeah, everything is here. So you can go here, all are here. Go to the Act. I think it's 21. Industrial is 21. Yeah, the Industrial Code is 21. Everything is here. Industrial Code 21. Where is it? Yeah, Industrial Code. So set up in 1967. Okay, by virtue of this IRA, power IC are held by the court. Not part of Malaysian court system, separate legal entity. Main function, the speedy and centralized settlement of the trade dispute without the hassle and the cost associated in normal courts. Okay. Court of equity. This one maksud is a fair court. The fair court, based on merits and good conscience, not legal technicalities. An employee appearing before IC can represent himself. Or if he's a union member, a union officer. Decision IC is final and conclusive, cannot appeal or review. High Court, Court of Appeal, Federal Court have the jurisdiction and check upon the dispute. Point of law only. That's all only. You cannot dispute final decision. Making a award shall have regards to public interest, financial implication, and effect of the award on the country, economy, and industry. IC may take account the agreement. Or practice between the parties, though it may award compensation beyond the terms of contract of service. The award too need not be restricted. What was claimed by the parties may go beyond if the expedient to do so. Jurisdiction, whole of Malaysia, to hear cases regarding unfair labor practice. All employment law, we can go to here. You can also go to High Court, but here the benefit is better. The award is higher, and you can get a reinstatement, you get back your job. So industrial court is better. So for employment, you go to industrial court, but you have to file your case within 60 days after you are terminated. This court is better. So you just click here. I think he can take you. Industrial court. Cut and paste. Never mind. So this one I buang. I go to industrial court. All right, here INDUST. Yeah, industrial court. Okay. Here's one. So everything is here. You pergi baca. So here we are industrial court. Okay, let me see now. If you any college, I want a good employer lah. I don't want the employer is unfairly expedient to do so or join. However, the IC may hear the case without the referral from the minister, but application either party. Okay, so you have this. Okay, look at this page, I explained it. See what it means, Okay. So, however, the industrial court may hear the case without the referral from the minister, but application either party. Okay, question on interpreting the award, collective agreement application. The minister reference dispute to the IC shall have not automatically given. Parties to dispute may raise the preliminary objection. Powers of IC. The IC is a creature of IA. The powers must be discovered from the four corners. All right, see what's the powers of the industrial court. Okay, let me see. I can find one more. Strike, I think not in yet. Here, misconduct. Misconduct under the Employment Act gives the employer the right to punish the employee. Most misconduct usually occur at workplace. Occasionally, however, there are cases of behavior or not direct connected with the job. Amounting misconduct. Example, behavior that tarnish the organization. Okay, the organization or loss. Actually, it was okay here. I don't know why I opened here. All this become red. think this fellow don't want let me cut and have a look at the question. Where is it? Okay. Give any 5 reasons for misconduct at the workplace and explain the typical stages of progressive discipline. So what you have here is misconduct. You explain what is misconduct, then you can support the case. Misconduct, yeah, right to punish and all that. What is misconduct? Holiday in Lisbon, improper behavior, intentional wrongdoing, and deliberate violation of the rule. Yeah, this one progressive discipline. So you take the least severe steps. Less serious. So normally you do counseling and then you give a verbal warning, then a written warning, then you do a domestic inquiry, DI. And then during DI, then you see whether you want to suspend him without salary maximum 2 weeks, or you suspend him nothing, or you demote him or transfer him, or you terminate. Interpret the what? Give or not give concise to CA. Hear cases of non-compliance, allow the discretionary application of either party. Vary any term or what CA to remove the ambiguity. Order compensation for a worker who has been unjustly dismissed. So you get back your job and you get back your money. Order reinstatement, you get back your work. This one, if you're government service, very important. You get back your job, you get your pension, you get everything, all the benefit. Okay, look at sometimes you don't want to go back, but you just want to clear your name. So reinstatement. High Court cannot give you reinstatement, only Industrial Court. And High Court, the award is higher. So you better go to High Court if anything happen. Look into the case, unfair justice and all that. All right, trade dispute. IRA recognize the need for effective machinery to settle trade dispute, provide means to make a simple and speedy possible. Section 35, this one is IRA 35. So you can go to IRA. Here, IRA. Is this act? Yeah, 35. Yeah. Then you look at trade dispute classification. Hold on, let me see. Okay, see what is this trade dispute? Explain to you. To equity. So according to equity, good faith, merit or case, technicality, legal form not taken account. Any minor, they don't take it by employer under the contract of employment or to work for him and all that. All right, trade dispute classification. Have a look and see what is this. Recognize a trade union by the employer, collective bargaining, non-compliance, interpretation. So these are all the trade dispute. Recognition of trade employer, all these trade dispute. Then if we have a problem, then they will listing. So you can see from here. Dispute. In making award, the industrial court shall have regard to public interest, financial implication, and effect of the award. Also take into consideration any agreement and code. No restrict the specific relief. All right, these are the stages. Look at the chart here. Officer, you report to him. So he will refer to Director General of Labor. He will refer to the Minister of Labor. So only the minister can refer to the industrial court. Minister will refer to the industrial court. So they arbitrate the what? Not satisfied, refer to High Court. This is the only point of law only. Okay, picket. What is picket? Picket is normally they make a lot of noise. Spare time and employees who are members of trade union. So after that, you come back to work. Strike. This one is more serious. Okay, see what's the strike? Serious. Picket is not too bad. Strike by noise. So this picket is simple. It's before the strike. There's a dispute, and then they try to settle the dispute, cannot, and then you go for strike. A lawful strike, one or law. Obtaining of communication. Okay. After picket tak boleh settle, we go strike. So it's difficult. All right. So next week, a class is here. 22. 22 is a holiday. Section 2, strike means a cessation of work by body or workman acting combination and connected refusal for under the common law. Okay, you refuse to work. So refusal of work, you can see from here. Dispute baru boleh ya. Employee, the workman must take a secret ballot before going on a strike. Those eligible to vote must submit the result Director General within 14 days. Wait 7 days before commencing the strike. The strike ballot is only valid 90 days after the date of strike. So not easy, yeah. So you want to strike can, but you have to follow the procedure. So if you follow the procedure, you will strike. You can go on the strike if you follow the procedure. You must be a member of a trade union. There must be a trade dispute baru boleh ya. There's no trade dispute, you cannot go on a strike. If there's no trade dispute, so once there's a trade dispute, no problem, can. Very true, okay. No workman shall go on strike under the following: during a pendency of proceeding, cannot after a trade dispute is referred to industrial court, cannot strike on that matter because the matter is already being referred to industrial court. In respect of matters covered by the collective agreement, in respect of matters under section 13.3, any management prerogative, very, very important. This one, you cannot challenge, because this is a right of the employer to hire and fire and all that. So, management prerogative. So you can strike on these matters. The procedure, then the strike will be considered as a legal strike. Okay, strike deemed illegal if it contravenes any of the legal provision of any of the object rather than the furtherance of trade dispute. Therefore, general strike, sympathy strike, wildcat strike, or political strike all illegal. So semua ni tak boleh a legal strike. Consequences: trade union, certificate trade union we cancel. Union and membership executive could be prosecuted liable. Member could be deprived. For workmen, shall be liable for imprisonment, shall be face disciplinary action. Okay, let me see if I can get for you one more question. Take B. These are some examples. So later, before the exam, I'll see the relevant questions. This one is on strike, I think. Yeah. Make financial losses, managing director, retrenchment. If carry out accordance with provision, also any two valid retrenchment. Purpose of any two types of valid retrenchment. Retrenchment here you have it. So you have the retrenchment. The types of retrenchment. I think this one is retrenchment should be yeah. Two types. Yeah, retrenchment. Yeah, retrenchment. What retrenchment? Section 21. The two types here will be this retrenchment on financial ground, retrenchment on one more. One is financial, the other one is wait. So retrenchment, financial ground, the other one ground of convenience at two. Let me see. Okay, take one more. Yeah, this. All right, have a look at this. Bring it down. All right, look at this question. These are like exam type questions, but these are quite straightforward. Just have a look. See how you're going to answer this. Okay, let's look at this question. Explain. Explain the consequences of being a contract service opposed to contract. So the differences are any two tests. So this one is the differences between COS and CFS. So employment, COS, CFS, you need to know the test. He said any two, you can give any two. Is that you can check and see. You can go under images. The differences contract service and contract for service, and then any two tests, any two from here. Any two will be okay. Okay. All right, we try to finish off this one first. Oh, okay. This one, Which one? Where's the other one? Okay. Stop. Look at what lockout is a bit more. Or legal strike. See what's a legal strike? A strike is deemed illegal if it contravenes any of the provision of the object. So you can see for strike, right? There's a lot of procedure need to be followed. So this one, you will most probably start with industrial action, picket. Picket. So take note of picket. Whatever I'll finish this one today. And most probably, I think I will go to a new topic. Next week is a holiday. Most probably will. Okay, Section 40, lawful for one workman to stay near. So picket is before you have a trade dispute, then you have a picket. There's a trade dispute. You cannot intimidate anybody, obstruct, and this one is during break time only. This one will lead to strike. Normally during picket, the employer should settle early. He knows there's a problem, he should settle here. He don't settle, then it becomes more serious. Strike is more serious, but only for union. If you have union, most of you will have a degree. You join any organization, they will say that you cannot join a union. Because they will claim that they provide you sufficient what do you call benefit, is it? So then any union. Okay, so you have to see, most probably, most of you will not join a union. Essential requirement for strike. Must submit the result to the Director General 14 days. Essential group tak boleh strike. Doctors and all that tak boleh. Kalau they go on a strike, then they can be terminated. Just now is contract doctors. Tak sama. Contract doctors, they got nothing to lose. They're on contract only, not the permanent. No workman essential service can go on a strike without giving the employer notice. You can strike, but you have to give 42 days. 21 days before such strike and before the expiry of the date. Okay, this one all you can read through. Workman shall go on a strike, shall not go on a strike for here. 1, 2, 3, 4, 5. Tak boleh strike. During a proceeding upon inquiry, after trade dispute, refer to IC. Where there is an concise by IC, the respect of section 13.3, management prerogative. Hire, fire, transfer, promotion, all semua tak boleh. Public service, government, yang di-Pertuan Agong have withheld consent. He said cannot strike. Habis. Police, army, semua tak boleh strike. A strike is deemed illegal if contravening any of the legal provision and object. Therefore, general strike, sympathy strike, wild strike, all consequences. Certificate trade union cancel. Union and member executive will be prosecuted, liable for fine. Members can be deprived of their membership. Workmen shall be liable for imprisonment, shall be liable for face disciplinary action. Okay, lockout. What is a lockout? There's a bit more money. Okay, I think lockout. Yeah, and one more, that's all. So I will look at one more question for you.